copyright. We're going to deal that particular issues in detail. So this issue of copyright piracy is of transnational in nature, means it is transboundary in nature. It cannot be confined only to a territorial spheres. So there was a need and necessity to make an attempt where you can tackle this infringement of copyright or a piracy in copyright by creating a convention, by entering into a convention where all the members should reciprocally join their hands with respect to the prevention of piracy in copyright. Besides this, there is a WIPO copyright treaty which is called as WCT. Besides this, there is a WIPO phonograms and performers treaty, WPPT. There are various conventions which are in existence which is relating to a copyright. So friends, the copyright, the time when it came into existence has seen a sea change. Like various aspects have been included within the purview of the term copyright. The time when it came into existence, the only meaning of copyright which can be given is a literary work. If a person writes a book, he has a right over that particular book for a particular number of years, and he only has a right to reproduce or right to make the copies of that particular book, and he has the right to translate that particular book. So various other rights. As the time went off, the term copyright as well as the author, who is the originator or a creator of a work, is called as an author under the terms of Copyright Act. Both these terms got expanded to include various other aspects within the purview of the term copyright. And as we know that we have a fundamental duty where it says that every individual should strive towards a scientific temper. Like you have to contribute scientific temper, come out with a creative innovations and inventions so that we can achieve academic excellence as well as the social and economic development. And we also have a principle like India should have a foster towards international relations, like India should in good faith respect the treaty obligations which India has entered into. So India being a member of all these conventions, it is an obligation, like a moral or a duty on the part of a state to give effect to these treaty provisions in a good faith. In the earlier discussion itself, it was pointed out that basically these international conventions are not binding upon a state. It depends upon the international law which is prevailing in that particular country. Most of you might be aware of this monistic theory and dualistic theory. There are countries where there is no distinction between the domestic law of the land, municipal law of the land, with that of international law of the land, international law like United States. There are various countries, dualistic countries, which requires a theory of specific adoption. I mean to say, though we are party to an international treaty, in order to give effect to that particular provisions of the treaty, there is a requirement of enabling legislation. We have to enact a law in order to give effect to the treaty provisions. India is adopting this dualistic theory. So any convention or a treaty which India becomes a member directly will not be binding upon Indian government unless and until there is a legislation which has been enacted in pursuance of the treaty which has been entered into by India. This is a reason where we have enacted various legislations relating to protection of intellectual property rights. So friends, already an idea relating to various facets of intellectual property rights, its scope and utility, in brief, even with relating to the copyrights, have been dealt with the earlier paper presenters. So my focus here is to confine copyright, and Siddharth from Lakshmi Kumaran and Sridharan, he was pointing out, in order to understand in intellectual property rights, you need to have the technical flavor, a technical flavor. So my attempt here is to delete that particular legal jargons which defines various kinds of work in which the copyright subsists, and try to make you understand in a simple words with the examples how the copyright subsists and to what works the copyright exists in India. Economic scene of a copyright, where even our principal was pointing out artha, kama, moksha. like artha, wealth. Let us focus upon the economic scene of this copyright. So friends, a person who invests his judgment, labor, skill, and ultimately if somebody reaps the benefit of that particular hard labor, artha becomes vyartha. Artha becomes vyartha of Kannada. By investing time, labor and hard work he has produced, he has come out with a book, and somebody goes on reproducing the book and starts selling in a pirated version. So a person who has done in order to obtain artha, his work become vyartha. So that in order to look into the fact that it shall not become vyartha, we have a laws which protect the copyright in India as well as other countries. So friends, economic scene of the copyright. Just look into the economic analysis of this copyright, what role it plays in an Indian legal system. See, India is the largest audio cassette market in the world in terms of number of units sold. So India is the most largest country in the world in terms of the units which are sold in audio cassettes. Still in the village, you can see this audio cassettes. Might be in rural areas, like still the technological effect of CD, DVD has not yet reached, has not yet percolated into a rural area. Still, we can see this audio cassettes which are in existence. And the survey which was conducted by a government of India, like this was the latest statistics which I was able to get. In 1996, India's turnover in cassette and CD industry stood at 105 and 605 million. So it is 605 million. 105,605 million. This was a turnover of Indian economy with respect to the copyright industry. Like we are going to look into various activities which can be brought within the purview of the term copyright. Look into the other version. In 1996, India exported softwares worth of 39,000 million to the globe. 39,000 million rupees worth softwares was exported by India to another countries. Just assume about a situation, if India is exporting a 39,000 million rupees, what is a foreign exchange reserve which India is going to derive out of this particular transaction? So the economic scene of a copyright which I am keeping in front of your eye relating to the economic analysis of copyright industry in India. So friends, in the year 1996 itself, more than a decade, if we can have a 39 million rupees of turnover, look into the progress which we have achieved in today's. So a greater hindrance with respect to the development of copyright industry was piracy in copyright, piracy or infringement in copyrights. So next, in 1996, India exported 1,120 million worth books and other printed material. So India exported more than 1,120 million rupees worth books as well as printed material. So this is an economic analysis of copyright where we can understand what importance this copyright industry plays in Indian scenario. So friends, we have looked into the economic analysis of the copyright. We have also looked into an introduction where how the law was in existence before independence. Now let us focus upon the meaning of the term copyright. See, just at an outer glimpse, we will look at a Black's Law Dictionary, how he defines the term copyright. Later on, we will move on to a layman language in order to say what exactly is the copyright. See, Black in his Law Dictionary defines this term copyright as the right in literary property as recognized and sanctioned by law. Means copyright is always a creation of a statute. A statute protects the rights of the workers who comes out with their original creative works. And an intangible, incorporeal right granted to an author or originator of a literary or artistic production. So it is an intangible right, incorporeal right, which has been guaranteed to a person who comes out with his work. Thirdly, he is invested for a specific period with the sole and privilege of multiplying copies of the same and publishing and selling the same. Means only that particular person for a specified period which is specified in the law has a right of multiplying the copies, reproducing the copies of a literary work which he has brought. So this is a meaning of copyright which has been given to a term in Black's Law Dictionary. But friends, the development which has taken place, and in current scenario, even this definition does not suit to the copyright which is existing in the current scenario, because the copyright not only includes literary and artistic works. Besides this, there are broadcasting rights, there are performers' rights, there are computer softwares, computer database, which is also brought within the purview of the term copyright. Next. See the statutory definition which has been given under the Copyright Act 1957. What exactly the statute is saying with respect to copyright? It says the exclusive right to do or authorize others to do certain acts in relation to literary, dramatic or musical, computer program, artistic works, cinematographic films and sound recordings. Like an exclusive right, when we mean the term exclusive, excluding all others, only the person who has a right, he has a right to do or authorize others to do certain works, certain activities with respect to all these kinds of works. Next. Works in which copyright subsists. So friends, now we are discussing there is a copyright over which a law protects if you have come out with your own intellectual ability. What are the works in which the copyright subsists? The law confers a copyright protection to various kinds of activities, various kinds of works. Which are those works? Which are those kinds of activities which are protected under copyright law? It's literary work. Literary means anything which is in writing. Writing includes anything which is typewritten, which is printed, which is handwritten. So literary work, if a person by exercising his own intelligence comes out with a book or a novel, then he will get a copyright under the facet of literary work. It is a literary work. Anything which is in writing. An issue arose in the year 1994. Even softwares, it is in writing. So whether the softwares, whether the writing which exists in digital form can be brought within the purview of the term literary work. This was an issue which was in debate. Later on, the 1994 amendment to the Copyright Act added the computer softwares within the purview of the term literary work. And to give effect to this particular thing, we also have an Information Technology Act 2000, where section 4 says anything which is required to be in written is deemed to be satisfied, is deemed to be considered as in written form, even if it is existing in digital version, so as to make a subsequent reference to it. If you are keeping any particular matter in a CD, in a flash drive, in a pen drive, in a floppy, if you can make a reference to it, that also satisfy the literary work. So that computer softwares as well as the database which can be stored in the hard drives was also brought within the purview of the term literary work. And not only this, an amendment also speaks about the infringement of a copyright which exists in digital form. So this literary work is ever expanding to include various kinds of activities within its purview since from its inception. Earlier only books, later on even the computer softwares, computer database were also brought within the purview of the term literary work. Next, dramatic work. A dramatic work, drama, a work involving a dance or a mime in a dumb show where you are not going to speak, a mime, an entertainment in a dumb show. With respect to this, in the year 2009, there is a decision by Supreme Court of India with respect to this dramatic work. The case is of Academy of General Education Manipal, Udupi Manipal, our Manipal versus B. Malini Malya. This is a decision where all of you might be aware of Shivram Karant. What is he famous for? Yakshagana drama, which is also one facet. Yakshagana. So the traditional knowledge of Yakshagana was infused with a new creativity, and he came out with a concept called as Yaksharanga. He came out with a new concept, came out by infusing a originality in the traditional thing of Yakshagana. He discovered, he gave a picture, he brought into an existence Yaksharanga, which consists of so many dramatic scenes like Naladamayanti, Abhimanyu, Chitrangada, various 7 kinds of classifications. And this Academy of General Education performed this Yaksharanga in Delhi. Shivram Karant, at the time of his demise, he wrote a will in all his property, including an intellectual property which can be assigned and transferred to Malini Malya. It came into the knowledge of Malini Malya. She is also from Udupi. She challenged it before a court of law in Udupi, saying that this has infringed my copyright. Copyright can exist even in literary work as well as dramatic work. And a dramatic work which has been created by Shivram Karant and Yaksharanga, including 7 types of new roles in a drama. This was performed in a Delhi by an Academy of General Education. This was challenged by Malini Malya. Then Udupi court gave a decision in favor of Malini Malya. Again the matter went to a High Court of Karnataka. High Court of Karnataka again said, looking into the will which was executed by Shivram Karant, it was specifically mentioned in clause 11 and clause 12 of a will that all the property, including literary as well as all other copyrights which he owns, is transferred to Malini Malya. The case went to the Supreme Court, and this case is decided on 23rd January 2009. Not even 1 month has passed from the decision of a Supreme Court, and the judgment is delivered by Justice S.B. Sinha, one of the renowned judges of Supreme Court. Justice S.B. Sinha came out with a judgment. The performance of a Yaksharanga, which was created, it was a intellectual brainchild of a Shivram Karant, did not amount to violation of copyright. Doesn't mean to say that there doesn't exist a copyright in Yaksharanga. There is a provision under Copyright Act section 52 which speaks about fair dealing, doctrine of fair use, where for an audience without collecting any fees, if it is performed for an educational purpose, that does not amount to infringement of copyright. Here it is an Academy of Education which is imparting an education in terms of fine arts. If it displays a drama which was created by Shivram Karant, that does not infringe the right of Malini Malya. So this is a recent decision in 23rd January 2009, dramatic work, like a drama. Even those rights are protected under the copyright. Next, artistic work. Any work which involves an artistic skill, though it might be devoid of artistic quality, like painting, sculpture, engraving, photograph. One fine day, you happens to paint a very beautiful picture, and some other person reproduces that particular picture, painting, and he starts making commercial use of that particular painting. That amounts to a violation of copyright, because it is an artistic work. By exercising his own intelligence, by judgment, labor and skill, he has painted. If you reproduce that particular multiple copies, if you produce, start selling that painting, then where is the value for the person who has exercised his intelligible character through which he has come out with a painting? Artistic works includes various aspects within its purview. Even dramatic works includes a scenic arrangement, a choreography. All these particular aspects were also brought within the purview of the term dramatic work. Next, musical work. A musical work, including music and graphical notation of a music, which does not include anything which is sung or spoken or act which is performed with it. It is only a graphical notation of a music, which is also entitled for a copyright protection. A composer who comes out with a graphical notation of a music, and one person, like by investing his time for more than a year, if a composer comes with a new graphical notation, if somebody happens to copy the same, then naturally it amounts to violation of copyright. Sound recording includes a recording of sound which has been done in any device so that it can be reproduced. So friends, if you go and see these particular definitions in a Copyright Act with the legal jargons, it will bounce over our heads. So understanding the theme of the seminar, it is for a layman. I'm trying to put forward before you in a simple words. And cinematographic film, the movies, films. I'll just tell you the definition of a statutory definition of this cinematographic film. Copying of a visual recording of an image on a moving object so that it can be reproduced on any medium. So this is how the definition begins with a cinematographic film. Cinematographic film is nothing but a movie which has been taken, and the producer who has invested crores of rupees and come out with a new movie, if somebody pirates, like multiples the copies of video CDs of that particular movie, what about the rights of a producer who has invested crores of rupees in bringing out a movie? His right is protected under Copyright Act. So the law protects, copyright is a creation of statute which does not exist in vacuum. The law protects the rights of an author who comes out with a work for a specific period of time. If you come out with any of these works by your creativity, then you have a rights of reproduction. You have a right to reproduce the work which you have come out with, a literary work. You have written a book, reproduce the book depending upon the demand which is in existence, and earn out of that particular sale or commercial exploitation of that particular property, which is also one facet of intellectual property. And communication to the public, like communication to the public means you are going to make it available to the public to be seen or to be heard either by way of diffusion or by way of a wireless mode. So when you come out with this particular work, cinematographic film, you have a right to communicate it to the public, and you only has a right to communicate it to public, none other than you. Adaptation, you come out with a beautiful novel, one fine day you think that novel shall be converted into a movie. Fine, all these rights vest with the author of a copyright, is a owner of a copyright. Adaptation, you have written a novel, now you want to convert into a movie. You have written a novel in English, now you want to convert it into Hindi, Tamil, Malayalam. All these rights are vested with the author of a copyright. Translation of the work, so that's what we are discussing. So friends, copyright is a multiple rights, it's a bundle of rights. A same person gets a multiple rights in terms of reproduction, sale, distribution, adaptation, translation. So one nature of copyright is that of multiple rights which comes with itself. Next. See, I'm just going to give you a glimpse of various kinds of artistic works where it is subjected to a copyright protection under the provisions of law. Don't you think these kinds of work needs a protection? A person who has invested his brain, energy, skill, and has come out with these kinds of work needs to be protected. Just go on to few clippings. Next. If a person paints like this, doesn't it require a protection under law? Next. See the paintings which has been done. Painting can very well be brought within the purview of the term artistic work. If a person paints so beautifully, and if somebody happens to take a multi-copy of that particular thing and sold in a market and in the open streets, then where is the value for the creator of this particular painting? Next. See, the works of architecture. The works of architecture is also subjected to a copyright protection. And a person, by his blood and sweat, comes out with a architectural work, with a graph. Like, doesn't that architecture work needs to be protected under the law? If somebody invests 18 years, 19 years to come out with one model of a building, and next day after it is constructed, next to that building, if another person constructs the same architecture, doesn't it amount to a violation of a person who has invested more than 18 years to come out with a model of an architecture? This is also a work which can be brought within the purview of the term artistic work. Next. Sculpture. Sculpture. This is also one of the facet, one of the limb of artistic work, which itself is one of the major limb of copyright. So a person, a sculpture, doesn't his rights to be protected